What are the contours of that? That's one aspect. Another aspect of it is that this being a jurisdictional fact, because if he comes to the conclusion prima facie that it is not a case of a split, but it's a case where you have the control of the political party, you go out of the 10th schedule. So there is severely contested by the other side. So this goes to judicial review on this very point, invariably, in reality. So the speaker has taken a prima facie view and adjourned the matter till determination by the election commission is what the order will be. So he says this can't be done, and according to it, the entire thing will revolve around numbers or the material that is there before the speaker to take that prima facie view. So it's a very slippery ground in that sense of now expecting the speaker to take a prima facie view and the kind of a material that is available for him to do it. And what kind of prima facie case? I mean, except that there are signatures, as in the case of about 34 MLAs, and aspects such as how much of the political party has vouchsafed for one group or not, how much will be available at that stage. So as a principle, I would take it that your submission is that he would only take a prima facie view and refrain from proceeding with 10th schedule, expecting that the election commission will determine the matter. And after the election commission says that it is not a case where the other group has control, matter comes back to the speaker and he will determine the case. That's the way you are.
And just to add to it, my lords, because a constitution bench of this court in Rana has taken a view that you will not embark on an independent inquiry, dehorse disqualification and a prima facie view. And prima facie view on split, yes. And I tell you, lordships, why? The speaker cannot get into something. The Election Commission of India has the machinery to determine that. But the other problem which also arises in this matter is, the lordships are right. There could be a problem, the peculiarities of a case. The problem arises also out of saying two distinct entities, the legislature and the political party. We are undermining the importance of overwhelming members of a legislature party, their resolutions passed, people supporting them, a competent body deciding on the issue. Because that is the only argument being made, that the speaker today should have gotten into it and should have not gone only by what the legislature party said. But that is a presumption that it's only the legislature party. That presumption in law is wrong, because it is never alone a legislature party. They're both integrally connected, organically connected, co-joined. You can't presume when you say that it's just one and not the other. And that is why from the symbol share order, dying to Sadiq Ali, everywhere the word used is existence, recognition, continuance of political party. You fall back also, amongst other grounds, also on the percentage of votes, the MLAs, the MPs, and an indicator of it. And that's why I said, my lords, these are all indicators in furtherance of what we are arguing, including para 4 10 schedule. Now, my lords, that whole deeming fiction, why is it there? And in any case, my lords, to go back to what your lordships asked me, today the question is, will your lordships in a case like this get into and say that we'll decide it? Because because they say it's a per se case. So every second party will come to court and say it's a per se case as per us. And you don't need to go anywhere else. No other constitutional authority needs to get into it. And your lordship should act as the court of first instance and decide all these issues. So you are taking away and depriving every other competent coordinate constitutional authority of their jurisdiction and are being asked to act as the court of first instance in all these matters. And Rana, my lords, as I had submitted, was a completely different case. In fact, Justice Nariman, in the judgment which Mr. Salve also just read out, also deals with this issue, saying that for 4 years something was pending in the High Court. And then it came there. And then it was remanded back. It was being asked to be remanded back by the High Court. At that stage, the Supreme Court said the Assembly's term is coming to an end. So your lordships were said that it's been done. But when has it been done? In what circumstances has been done? Is the law of the land that all other authorities will be deprived of their jurisdictions? Because in the peculiar facts of Rana, it was said that court in a particular case could decide it in the manner it did. It can't be. Then, my lords, as I had respectfully submitted, the two letters I had pointed out to my lords, which clearly demonstrates a practice. Now, today to turn around and say, so when you issued the letters, it was fine. At that stage, the practice was fine. And necessarily, my lords, from the rules, as I said, that's the only way to do it. If a member of the leader of the legislature party has to be a member of the house, the rules say he will communicate. The rule says he will point out changes, he will point out designations. Disobedience of the whip, he will point out under Rule 3.5. not those rules, I'm not rereading, my lords. I've taken my lords through each of those rules. Until unless your lordship so directs me, I'll read those rules. It's provided therein. So where will the speaker today embark on this independent inquiry on disobedience of the whip, etc.? It has to be within the contours of what the rules provide and the constitution provides. Will he go and call members from everywhere, political party? And then the argument made to your lordships was that at that stage only the leader of the political party should be in direct touch with. Can't be. We have to go by what the constitution and the practicality says. If there are overwhelming majority today saying that we don't have a faith in the leader, let's test a proposition. Suppose an overwhelming members say we don't have the faith in the leader, but we want to be within the political party. So to say speaker will get into an area where a constitution bench says, yes, you will take a prima facie view. Now, those contours of how the speaker exercises jurisdiction will first be left to the speaker to exercise it, because judicial review is always available to your lordships of a decision by the speaker. What contours, what standards, what principles the speaker follows. After all, in Quixote, that's why your lordship said no quo timid, no interim injunctions. Let an order come, then we'll examine it. And today your lordships are told that in the legislature party, this was only the legislature party, and they've hijacked the political party. And because the deputy speaker no longer, it's another speaker who's deciding, thus your lordships must decide it. That's the argument being made today. And it's a per se case. So all authorities, all principles be ignored because we say it's a per se case, your lordships must decide it. And because Rana had decided it. Then, my lords, another question that your lordships had earlier also posed to us, and today also your lordships posed to Mr. Salve also, was on relating back and whether applying prospectively. My lords, Rana, as I had respectfully read out, was a decision where the Supreme Court exercised its jurisdiction to say that on the day disqualification was incurred, the split had not happened. The speaker went ahead with the split and not decided the disqualification issue. This court said, when it said it relates back ex post facto, the facts as far as disqualification are concerned will be seen on the date when they incur disqualification, not by subsequent split in the party that may have happened. That's an event wholly inconsequential for deciding disqualification. Ex post facto was used in that context. Now that ex post facto is being used to argue before your lordships that if they are disqualified, it will relate back to the day they incurred disqualification, and thus all their exercise of votes, including the floor test vote, will be annulled and is vitiated. That's the argument being made before your lordships. Now, my lords, your lordships have repeatedly, from Kuldeep Bishnoi, Pratap Gowda Patil, Shivraj Chauhan, Nabam Rebia, repeatedly reiterated that till a disqualification petition is pending, an MLA has every, or an MP has every right to participate, whether it's for a floor test, whether it's for a disqualification, for a removal of a speaker, or in a floor test, has every right to participate. Now, if that is the law laid down by your lordships, how can it now be argued? And I showed my lords Shivraj Chauhan where exactly the same argument was made and rejected. And your lordships consciously talked about the 10th schedule being completely different from the other part. The two couldn't be mixed up. Now today the same argument is being made to your lordships. So every bill, every apportionment, every decision taken will tomorrow be annulled, because as per them, the disqualification will relate back to the day you incurred it, and thus all decisions and participation in the House stand vitiated. Now, Shivraj Singh Chauhan, your lordships had consciously said, and categorically said so, that exercise of powers by the speaker to decide resignation or disqualification exists in a separate realm than a floor test. Then the reason I pointed out, because my lord the Chief Justice had then said that could it be argued that that was a case only relating to resignation, and I respectfully submitted that no, your lordships did consider the issue of disqualification in the matter and floor test. You can't let the two be interfered with. Now today your lordships are repeatedly said, thus because it would be vitiated, the whole thing is annulled. And I'll come in the end, my lords, lastly to what all your lordships are being asked to annul. That I'll come to as a consequence of once I complete all the acts which will flow in the waterfall as per them which should be annulled. Because your lordships order led to the toppling of a government, which of course is another argument which I'll deal with. Now, my lords, Article 189 subclause 2 was respectfully read out to my lords, also for the same proposition that even if a person voted who was ineligible, the votes will be continued to be counted. Again, in furtherance of the same argument that I am making, that I am drawing sustenance from. Also, my lords, Article 190 subclause 3, read with Article 191, says that vacancy arises when you incur disqualification. And when do you incur disqualification? You incur disqualification either under Article 191(1) or 191(2), which is a 10th schedule. The Constitution does not say that the moment a disqualification is filed, a vacancy arises. Again, an indicator of the fact that till a decision is taken on the disqualification, how do you presume? And my lords, the dangers of that is that we will have today constituencies unrepresented in parliament and in the legislature because a disqualification petition is pending. That's one. Please see, for a bedrock of democracy where every constituency ought to be represented in parliament, we are being today told that because a disqualification petition is pending, should go unrepresented, a constituency. Or
Mr. Kaul, if we accept your submission, in that case, suppose Speaker doesn't decide it for number of years, correct, 6 months or 8 months, like observed by Justice Nariman in the judgment, correct, and what was observed by Justice Reyes Verma in that Coelho judgment. In between, correct, so many things happen. One thing, you can argue one thing, that whatever is in between decided on, correct, cannot be annulled, correct, or cannot be reverted back, correct, or cannot be recalled. But to say that the disqualification cannot be from the date on which the disqualification takes place, it will be too much to argue.
my lords, I did not for a minute, Illochus are absolutely right. I did not for a minute, did not say that
He will
even.
be giving
No.
premium to the inaction on the part of the.
I'm not even saying that, my lords, because today on that there is a complete answer in Rana. I'm not even saying that. I'm just saying till the disqualification order is passed and MLA continues with all the vigor and robustness and legality at its command under the Constitution to exercise his rights as an MLA or an MP.